Mr. Smith.
Much obliged. My ladies and my lord, I wonder whether before I go on the law, can I refer the board to some of the passages of the judgment in the Court of Appeal in which the Court of Appeal did with the assessment in respect of the inference drawn from the undisputed facts. If I ask the board to look at Volume 2, the judgment of the Court of Appeal starts at page 857, but can I take you to page 880? I should say 878. 878.
878.
878. And if you look at paragraph 54, under the heading Appropriate Inference, given that the appellants did not have any measure of protection under the Rent Restriction Act, we are therefore constrained to revisit the issue in the light of the actual legal position. We therefore need to consider what would have been the appropriate inference to draw from the permanence of the buildings erected on the land and the subsequent improvements thereto, acquiesced in by the respondent and his predecessors. Any such inference, of course, must be on the undisputed evidence and consistent with the case as pleaded. And then at paragraph 55, given that the appellants did not enjoy statutory security of tenure, it must be considered what on a balance of probabilities could account for the fact that the appellant each constructed permanent structures upon their entry into occupation of the respective portions and proceeded thereafter to invest in renovations and improvements to the extent that the houses are now worth respectively, and it gives the figure, substantial sums. Then,
could I just ask you, because I'm not familiar with the physical layout of the site, is it unusual in Trinidad to erect a permanent structure rather than one that simply rests on the ground if you're building a house?
If I could answer that question. You have both types of, but a tenant normally would not build permanently a fixed house. Would probably build a chattel house, what used to be called a chattel, and then would probably extend it and may have some concrete portions, but something that will be easily demolished. Not something that will be so, as in this case.
Thank you, because we've read about the plumbing that was instituted,
yes,
and the digging out from the mountain.
Yes, yes.
But that would be relatively unusual for it.
I would think so, my lady.
I mean, I was going to ask you about this, because isn't this what Lord Walker was describing in the case we refer to Gopal? Could we perhaps have a look at that? I'm sorry, just pick up that point. This is on Bundle 1, tab 11, page 3260. 3260.
Much obliged.
We have paragraph 5. He talks about this picture emerging of tenants occupying small houses which they erected at their own expense with the consent or acquisition of the landlords. And then he talks at paragraph 6 about one starts with sort of chattel houses and then they start becoming more substantial, concrete walls and drainage and everything like that. And then paragraph 7, this is a social problem. And over the page, because of the affluence, instead of having chattel houses, tenants started to build real solid houses, houses of concrete and steel. Well, they still continue to call them chattel houses. And of course, this was exactly the problem which the Land Security Tenure Bill in 1981 is passed to deal with.
Yeah,
so it's not unusual, it seems to me.
But you would have cases, my lord, you would have cases where a person, in my experience and what I know, is that they would not start as a tenant building a permanently fixed house. they would start as a tenant, probably building a movable house, because the whole purpose was to move it. And then over the years, they would probably build concrete structures. And it would seem that what happened is that over the years, because people had started building these chattel houses, and then they spent a lot of money in building concrete houses as part of, well, concrete portion of it. Parliament decided to intervene and to change a chattel house to one that is permanently affixed to the ground.
But so, I mean, the difference here, you're saying, is that they built a solid house from the start
initially,
in the 60s.
Yes, initially.
Is that the point?
Yes. In other words, if you go as a tenant on a piece of land and you have an annual tenancy, you can be removed at 6 months' notice. So you would not start digging into the mountain. It's not, the inference is that you would, a person would not start digging into the mountain to level the land, to build from the beginning these permanent structures. So it is in that context the Court of Appeal who...
No, I mean, I understand what they're saying, and no doubt the Court of Appeal would have been aware as a local court of all this history.
Correct.
But I was just trying to understand the difference between this situation and the situation which is described by Lord Walker. I think I have your point on that.
Much obliged.
Thank you.
Oh, sorry. We go to paragraph. Where did I reach? Rob?
It's all right.
55. And then can I take the board to paragraph 63? It's common ground between the parties, and I'll ask the board to read that at its own leisure. Then you would see at paragraph 67, the inference that arises on a balance of probabilities from those factors would rather be the appellants enjoy no statutory protection or statutory security of tenure at the time that they constructed their homes. The parties were not strangers to each other, and alleged agreements between them had to be considered in that context. The investment in permanent structures at the inception, and this is a point that at the inception of the occupation, would more likely than not be based on a perception of security of tenure greater than that of a yearly tenant expellable at 6 months' notice. Such a perception of security of tenure would be consistent with an option to purchase given to them by the Andrews, even if not under the same terms as they sought to portray, as to the price at which that option could be exercised. The Andrews and subsequently Hanif did not ever attempt to serve them notice to quit despite seeing the structures erected and the subsequent improvement. This fact is independent of any consideration as to the specific improvements or expenditure alleged or proved, as the trial judge found that the values of the houses were set out above. The likelihood in this specific case of the alleged option to purchase giving rise to estoppel by acquiescence when the Andrews and the then Hanif stood by while relatively significant expenditure given the appellant's means were incurred before 1981 on the permanent structures. These being matters common to the parties, the appellant's occupations, in addition to pure tenancy rights, had in addition the indicia of proprietary estoppel by acquiescence, and that is so whether or not all the terms of the Andrews Agreement are accepted. So it is in that context that the Court of Appeal drew the inferences. And therefore, my lady, you were shown, my ladies and my lords, you were shown this morning the case of Sterling.
Yes.
And I'm reading from the transcript, not the, I think that was passed to the board. At page 11, it's written at the bottom of the page on the right-hand side. Yeah. And I think... Yes, it's a case of Bibby.
It's Bibby and Sterling.
Yeah, Bibby and Sterling. It seems to me that the Court of Appeal and the board is in a similar position as Lord Justice Millett was in this case. Because if you look at page 11, the third paragraph, there is no direct evidence of what rights of occupation of the strip Mr. Sterling believed he had when he built the greenhouse, or Mr. Holmes was aware of his belief. Both facts have to be inferred, if at all, from the evidence that Mr. Sterling built the greenhouse and that Mr. Holmes knew that he was doing so. And if I fast forward a bit, I go to the next page, the second paragraph. This depends on an assessment of the scale of the operation involved in the creation of the greenhouse. No one would build a bungalow on land belonging to another unless he believed that he owned the land or had a long lease. So,
That is a very positive statement of fact, based on, no doubt, Lord Millett's experience of life.
In this country.
In this country. But how far that's translatable to Trinidad, we shall just have to do our best.
we are saying in this particular case, that would apply, because...
But I mean, it is, like I said, it's a question of fact.
So I now turn to before the luncheon adjournment, I was dealing with the first issue, that is the Court of Appeal. Was the Court of Appeal entitled to revisit the question, what findings should be drawn, on the question of what findings should be drawn from the permanence of the respondent's home? And I'd started the submission on that, and I was about to go to the relevant law. I would submit that the Court of Appeal was entitled to revisit those questions because the judge made material errors of law in answering them. And further, the Court of Appeal was well equipped to answer them. And I wanted to refer the board to the well-known case of Beacon Insurance, just for a short while. Beacon Insurance and Mirage Bookstore is Volume 1, Tab 8 of the Bundle of Authorities. And if I can take the board to paragraph 12 at page 3227. And if I can take the board to there's a heading, the role of an appeal court, but if I can take you down to letter G. The court is required to identify a mistake in the judge's evaluation of the evidence that is sufficiently material to undermine its conclusions. Occasions meriting appellate intervention would include when a trial judge failed to analyze properly the entirety of the evidence. And then if I go to paragraph 17 at page 3229. Am I correct? Yeah, 3229, paragraph 17. Where a judge draws inferences from his findings of primary fact, which have been dependent on his assessment of the credibility or reliability of witnesses who have given oral evidence and of the weight to be attached to their evidence, an appellate court may have to be similarly cautious in its approach to its findings of such secondary facts and its evaluation of the evidence as a whole. In Re B. A Child above, Lord Neuberger, at paragraph 60, acknowledged that the advantages that a trial judge has over an appellate court in matters of evaluation will vary from case to case. The form, oral or written, of the evidence which formed the basis on which the trial judge made findings of primary fact and whether that evidence was disputed are important variables. As Lord Bridge of Howick stated in White House and Jordan, and refer to it, the importance of the part played by those advantages in assisting the judge to any particular conclusion of fact varies through a wide spectrum from, at the one end, straight conflict of primary fact between witnesses, where credibility is crucial and the appellate court can hardly ever interfere, to, at the other end, an inference from undisputed primary facts, where the appellate court is in just as good a position as the trial judge to make its decision. I respectfully submit to the board that these principles are important for this case.
Could I just ask you a question? Did the Court of Appeal have to go about it in that way? Could they have said, but the judge has not dealt with the alternative claim in estoppel by acquiescence, and put on one side the question of the findings of fact?
Yes, my lady, because that would be a failure to analyze the entirety of the evidence and a misdirection of the judge itself in failing to make that finding. There is another case which, in the scheme of things, I passed it up, the Bahamas Air Holdings Limited, and Messier Doughty, it's 2018 UKPC 25, and if I take the board to paragraph 36.3,
where are we now?
This is a new,
paragraph 36.
A new case.
Yes,
well,
Bahamas Air.
it was among the 3 new cases that arrived this morning. You probably got it there. Bahamas Air.
Yes, ma'am.
Bahamas Air.
Bahamas Air.
Well, I did have it at one point.
Paragraph 36.3, is that?
36.3. Can I proceed, no, I'm
Is
just
there a spare copy?
There.
Is it on? Oh, is this one? Yeah.
36.3.
Okay. Which paragraph?
36.3. It's the last page, really, of the judgment. Principles of restraint. The principles of restraint do not mean that the appellate court is never justified, indeed required, to intervene. The principles rest on the assumption that the judge has taken proper advantage of having heard and seen the witnesses, and has in that connection tested the evidence by reference to a correct understanding of the issues against the background of the material available and the inherent probabilities. I now turn, my ladies and my lords, to the judge's material errors, showing how she went wrong and the conclusions to be drawn from the fact that the respondent had built permanent homes. The judge's reasoning is at paragraph 65 and 66. That is in volume 2. Page 598, 597, 598. And it's important for us to look at the contents of what the judge was saying here to see, in effect, what she meant. Paragraph 65, the claimants submit that the fact of the permanence of the buildings erected on the land and the money expended by them in this regard is evidence corroborative of the existence of the agreement. I do not agree. In my opinion, the nature of the buildings on the land and the rent receipts are equally applicable to a finding that the claimants were simply tenants of building land and under the Act, that's referring to the 1981 Act, and its predecessor, the Rent Restriction Act. Indeed, the rationale for introducing the Act was for the protection of persons in a similar position to the claimants, tenants of building land, who own large buildings that were incapable of being removed without being destroyed. And then the court went in paragraph 66 to deal with the protection given under the 1981 Act, saying for these tenants, the Act provided additional security of tenure in the form of a 30-year lease, etc., etc. So what the judge was saying was that the fact that the respondents built permanent homes is equally consistent with their being tenants of building land under the Land Tenants Act of 1981 and what she calls its predecessor, the Rent Restriction Act. That is clear in our respectful submission. She goes on to set out the security of tenure which is provided by the Land Tenants Act.
He makes the point that I put to you, which is that they're no different from the many people in a similar position
Yes.
who build houses without the title.
Yes, so she was equating it with other persons, not looking at the facts of the particular case. In effect, I would summarize the judge's reasoning as follows, my ladies and my lord. If the respondents believe that they had security of tenure, that does not necessarily lead to the conclusion that the Andrews promised them security, because such belief is equally consistent with the fact that the respondents had security of tenure under the two acts. That expresses a number of reasons why the judge's reasoning, a number of reasons why the judge's reasoning was wrong as a matter of law. First, the Land Tenants Act was irrelevant. It was in 1981. It did not apply to these houses at the time they were built. The judge placed emphasis on the security of tenure provided by that act, but it was not enacted at the time. By that time, Syra Mohammed had been occupying her land for 23 years, David Sami for 18 years, and Mary Gomez for 15 years. Second, the judge was wrong to rely on the Rent Restriction Act at all, because it was not raised at the trial in arguments or in evidence, or by the judge herself. She came up with it for the first time in a judgment, and I should mention to the board that this was a ground of appeal, and if I can refer the board to volume 2, grounds of appeal 10C. You have volume 2, 10C. Volume 2, 10C, it's at page 624. And if you see the last sentence, the learned judge erred in law in making this finding of applicability of the Rent Restriction Act when it was not an issue raised in the pleadings or in the evidence or in the addresses or by the court at the trial. The learned judge was plainly wrong to rely on it to explain the facts when it had not been considered by the parties or put to the respondent as an explanation. Third, the Court of Appeal was right to find that the Rent Restriction Act did not apply to the respondent's land because of the effect of the order of 1954. Can we go to bundle 1 of the authorities? And the order is at page 3116. Before we read the order, that part of the order, can I take the board to page 3094? That is the Act itself, as to the definition of building land in section 2 of the Act itself. building land, and it says what it says, but at the end, or land on which the tenant has lawfully erected such a building. So by the act itself, building land was land and building. And then by the order at page 3116, in the schedule, part 1, as from the 12th of February 1954, all new buildings, the erection of which was completed on or after that date, together with any land appurtenant thereto, to be occupied therewith. So this was excluding all buildings after 1954 with land appurtenant thereto to the building. So it
Mr.
was
Maharaj, as I understand it, we are asked to read paragraph 1 of the schedule with Article 2 of the order. The classes of premises described in the schedule are excluded. Okay, what premises are excluded? And Mr. Benjamin says the premises excluded are new buildings and land appurtenant thereto. So the argument against you, as I understand it, is that does not cover a simple letting of building land, but only premises of new buildings with appurtenant land.
well,
So how do you deal with that?
well, my lord, I think the order has to be read together with the Rent Restriction Act, which describes building land. And the Act describes building land as to include building. And in Part 1, the schedule in Part 1, it expressly says all new buildings erected after 1954, including the land appurtenant thereto. So if it was the intention not to include the buildings or the land, it would have expressly said so. But by this, Part 1, it is expressly including the land appurtenant thereto, and that is what the Court of Appeal found. Now, this was not an issue in the High Court, and it was not an issue argued in the Court of Appeal because there was a concession, and that concession was then withdrawn. So the only thing we have is a letter which the board saw today, and but it would seem to me that if you have a recognition that new buildings would be built after 1954, and you wanted to exclude those premises, and you did not want to include whether it's houses or land, you would have expressly said so. And if it is assuming it is ambiguous, it should be construed to give the purpose of the legislation, which is to exclude buildings built after 1954. And you have to build buildings on land.
Which is the section of the Act which gives protection against eviction?
Of the Rent Restriction Act?
Yes.
I think what is Section 14, but it's
Second restriction of right to possession, yes.
Section 14.
And that applies to premises to which this Act applies. Thank you.
There isn't a definition of premises in this legislation, is there? But looking at the definition of tenancy, which includes within premises building land, do I take it it's not, your submission that it's not just a house or a dwelling, it would also be a parcel of land?
If one looks at subsection 2 of section 2, that appears to be drafted on the basis that the word premises includes just land.
Subsection?
Subsection 2 of section 2, on page 3096. For the purposes of this Act, one letting of premises shall be deemed to be in the same category as another letting of the premises if both lettings are of a building land, which rather suggests that premises includes land alone.
I mean, I think that's clear from section 14 as well. I mean, interesting enough, this protects not just buildings occupied as houses, but also building land.
Yeah. I would ask the board to construe to give the purpose of the legislation, which is to exclude buildings built after 1954, but recognizing that the buildings have to be on land.
So land pertinent there to includes the land on which the building has been erected.
Yes, yes. And section 3 of the Act itself describe building land to include the building on which it means to let to tenant for the purpose a building use or the land on which the tenant has lawfully erected such a building. But we submit that in any event, even if the Act did apply, the fourth error of the judge was there was no evidence that it was relevant to the facts that the respondents' conduct, because there was no evidence that they even knew of it.
Now, where did the onus of proof lie? Was it for you to show that they didn't know of it, or was it for the defendant to show that they did?
Well, this was an issue which the judge decided on her own, without pleadings, without an opportunity. We never had any notice that this was going to be an issue.
No, I see.
And she decided to use this as a basis for rejecting the permanence of the building as being an inference in our favor.
That's a good answer, but if it had been in play before the judge, on whom would the onus of proof lie?
Well, the judge raised it to explain the respondent's behavior. So if it was pleaded as an issue, it would seem that the onus would be on the appellant to establish that it applied.
Okay, thank you.
And what I want to point out that all the evidence suggested that they did not know of these acts, even they were very unlikely to have known of it, because when they were asked about their knowledge of the later Land Tenants Act, none of them had known about it. And we have itemized that in our cases at paragraphs 50 to 52 of our case. And the fifth error of the judge was in that she gave no consideration to the level of security actually provided by the Rent Restriction Act. She was using the Rent Restriction Act to say it give them security of tenure and lumping it with the 1981 Act. But she set out in her judgment the protections given by the later Act, the 1981 Act, about the lease, etc., etc. But none of those protections are given by the earlier Rent Restriction Act. So those are the ways in which I say that the judge went wrong in her approach to this critical issue. It follows, and I respectfully submit, that the Court of Appeal was required to revisit the question and draw its own conclusions from the fact of the respondent's permanent houses. And that is what they did. And my learned friend has not shown that they were plainly wrong in doing that. The onus is on him to show that. The appellant submitted that the judge finding was in any event supported by other factors. There were, and we dealt with that in our case, the issues of credibility in this case, where the court found on the independent evidence, I would say the contemporaneous evidence, from the undisputed evidence, that these are the inferences, the reasonable inference to be drawn. It is of no consequence if a witness may have told an untruth or may have lied, as is being put it, on a matter which is peripheral. Because you would have cases where a judge would accept part of a witness evidence, but reject the other part of the evidence. So the fact that a witness has given evidence that could be categorized as an untruth does not necessarily mean you have to reject the entire evidence, especially where that other aspects of the evidence are supported by the contemporaneous evidence. And that is what the Court of Appeal did. The Court of Appeal took into consideration the issues of credibility, but the real evidence which was on the ground was sufficient for the court to draw the inferences. And on this issue, there's a case which I handed up, a case of EPI Environmental Technologies. And I think it's a well-known principle, but since my learned friend has raised it, it's Environmental Technologies, Inc., against Symphony Plastic Technologies, 2005 One Weekly Law Reports at page 3456. And it's a judgment of Justice Smith. And it's in the form of a practice note. And just the first paragraph, it is essential to evaluate a witness's performance in the light of the entirety of his evidence. Witnesses can make mistakes, but those mistakes do not necessarily affect other parts of the evidence. Witnesses can regularly lie. However, lies themselves do not mean necessarily that the entirety of that witness evidence is rejected. A witness may lie in an attempt to bolster a case, but the actual case nevertheless remains good, irrespective of the lie. And my Lord Wilson this morning talked about a criminal case. Even when a judge is directing a jury in a criminal case, the judge would warn the jury in assessing the facts. The fact that the witness lied doesn't necessarily mean that you ought to reject the witness evidence. You have to consider the entirety of the evidence. So where the Court of Appeal...
Is it called a Lucas direction in Trinidad? It's called a Lucas direction here.
Sorry, my lady?
Is that direction called a Lucas direction
Yes.
in Trinidad?
Yes,
It
my
certainly
lord.
is here.
In Trinidad and in the Caribbean, we follow all these principles decided as development in the common law. And convictions are reversed if these convictions are not, if these directions are not given. So that was the first stage that I talked about this morning. The second stage was that I mentioned, because I'm dealing with my submission in 3 stages. The second stage is that the Court of Appeal was entitled to find that the Andrews had promised the respondents an option to purchase, and the appellants had shown no reason to disturb that finding. Because the Court of Appeal were entitled to make their own findings on the issue, and because they were well equipped to draw inferences from undisputed facts, it follows that it is for the appellant to show that the Court of Appeal's finding was plainly wrong, or that it was not open for the Court of Appeal to make it. I submit that the Court of Appeal's finding was correct, that the Andrews had promised the respondent an option to purchase. At the very least, it was based on a sound assessment, and no material mistake has been identified, so there's no reason to overturn it. We have dealt with that extensively in our case, and it doesn't make sense me repeating it to the board. I ask the board to take note of that. And the judgment extensively dealt with the inferences which were drawn and why the court drew those inferences. But I wish
Maharaj, before the short adjournment, you drew our attention to quite an arresting witness statement of Mr. Nergoon.
Yes.
And over the short adjournment, I was rereading paragraph 36 of the judge's judgment on 588, if you have that to hand, where she addresses Mr. Nergoon's evidence. And she says that since there's in fact no dispute as to the claimant's occupation of the land, the only relevance of his evidence was to corroborate the dates they said they entered onto it. Well, you read us long passages about the extent of works needed to be done over a long period of time, witnessed by Mr. Nergoon. And I just wondered whether I had missed in the judge's judgment any recognition of the extent of the works that the 3 claimants and their partners had made.
None. There's, and in her passage, in her judgment, something. I am satisfied that given his age at the time and the number of years that have passed, the witness's recollection of these dates is not very reliable. But if you are living on land a long time and you're seeing people next door, you may not remember the exact dates, but at least you remember what they did on the land. And that is what Mr. Nergoon was saying. And what was very important in this case, to value the equity was to see what was the detriment suffered, the extent of the detriment. In these cases, my lord, as your lordship knows and as the board knows, that this is not a contract case. This is an equity case. So you look backwards. You look to see, well, what was the detriment? Because the detriment would assist the court in inferring what were the assurances. So the extent of the works done and the nature of the kind of labor which effected these works were very important if the court had to properly assess a proprietary estoppel as claimed. And the problem, if I may say with the greatest respect my learned friend has in this case, the problem is that when you look at the detriment, when you look at what was done, it cannot be said it is not a reasonable inference to draw that what they did was compatible with them having some security or some feeling that they would have security of tenure. Now, the Court of Appeal found that the part of the agreement that talked about the price, they were not prepared to reverse that. They found that the judge was entitled to do that. But on the facts of the case, as the Court of Appeal looked at it, it is not unreasonable for the court to find, because having regard to the fact that they could revisit the findings, it is not unreasonable for the court to find that having regard to the nature of the buildings, what was done on those buildings, the nature of the infrastructural works, the building of roads, and all that was done, these people would not have built that, I'm avoiding using the bungalow, would not have built those houses without having some security of tenure. They wouldn't build the houses if they knew that they could be moved in 6 months' time or with a notice for 6 months. And that is why the Court of Appeal found that even if you disbelieve the promise, the judge still had to determine an equity, estoppel by acquiescence. And the judge didn't deal with that at all. So with the greatest respect to the judge, it would seem to me that the judge did not fully appreciate the approach in dealing with a contract case and with a case on equity.
Can I go back a moment to the rent restriction?
Yes, ma'am.
And I'm looking at paragraph 71 of the judge's judgment at page 16, electric pot bundle, page 600, where she's dealing with, this is where it goes to the implausibility in her view of the price which was agreed.
Yes, ma'am.
But she says at 71, under the Rent Restriction Act, there was no requirement on a landlord to clear and develop building land before renting to tenants. This was land rented to tenants specifically for the purpose of erecting of a chattel house used as a dwelling, and so they would be required to clear and develop at their own cost. And then she goes on, why would they bind them to sell and so on. And anyway, they'd have had, as tenants of building land under the Rent Restriction Act, they would have had security of tenure. Now, I mean, although we've been looking at the Rent Restriction Act in the context of an erected building, until the building was erected, and it was simply building land, the Rent Restriction Act did apply, didn't it, at the time of this? I mean, it's a slightly curious position to me, but I mean, it seems that it only becomes excluded once the building is complete for some reason. So when they're entering into the agreement, and they're going in and spending all the time and effort clearing the land, they at least have the security then under the Rent Restriction Act. Is that right?
But it certainly, I would think, my Lord, that if the Rent Restriction Act applied,
Yes.
it would be the land and when you start to build a building.
Yes, but I mean, I wonder whether the judge, when she referred to the Rent Restriction Act, was doing more than referring to the applying to the building land at the time they went in and spent all this effort and clearing the land.
I think the judge, from the judgment, she was obviously referring to the houses,
Well, I wonder,
the house and the land.
because that's the context she deals with.
What paragraph you had read?
But I'm looking at paragraphs 71 and 72, where she's explaining how they would have had protection in relation to the clearing of the land and that. And at the bottom of paragraph 72, as tenants of building land, they would have had some measure of security of tenure, which I think is probably right, isn't it?
Even if it did provide some measure of security, it would not have provided security as the 1981 Act.
No, but as she said on the previous page, it's to deal with that problem that the 1981 Act has brought in.
But the judge was using it, my Lord, to, in effect, to dismiss the fact that she had to look at the permanence of the buildings. And she was using it to say, well, the Rent Restriction Act gave them security of tenure, and equating it with the 1981
I understand that, yeah.
So, I would ask the board to consider that this is an issue which we really had no notice of.
No, I've got it.
Yeah, we had no notice. And I would ask the board not to, even if the board is against our submission, not to make that the basis of the decision in this case, because it was not an issue raised, it was taken by the judge. Yes. In the Rent Restriction Act, if you didn't pay rent for 30 days, you can be evicted for arrears of rent. In the Security of Tenure Act, you had a lease of 30 years, renewable.
Oh, yes, it's much better under the Security Act, of course.
On this issue, I just want to address the board on a few points. First, the Court of Appeal restricted itself properly to an appellate role. It did not disturb any more of the judge's finding than was necessitated by her mistake. And it based its own inferences on the undisputed evidence. And I refer to parts of the judgment already, but I ask your lordships to note paragraph 54 of the judgment in volume 2, page 878, in which the judge expressly emphasized any such inferences, of course, must be on the undisputed evidence. And I already referred to the cases which show that the Court of Appeal was entitled on undisputed evidence to draw the inferences. Second, the appellant has not identified any evidence that the Court of Appeal ignored that would have compelled it to a different conclusion. The Court of Appeal considered all of the relevant circumstances and they set out those circumstances, and the board can see that at volume 2, page 878, paragraphs 54 to 67, at page 883. So the Court of Appeal was entitled to find that the respondents must have proceeded in reliance on a belief that they had some meaningful security of tenure, and this was indeed because the Andrews had promised them that they could buy the land at some time in the future. And the third point I wish to address is the judge's view that the respondent's story was simply too inherently improbable. The Court of Appeal disagreed that the story was improbable, save for the respondent's claim as the price at which it would be allowed to buy the land. They would be allowed to buy the land. The Court of Appeal did so, having given proper weight to the factors that the judge wrongly dismissed, and we respectfully submit that they were surely right to find that the respondent's claim was not so improbable in all the circumstances. I would ask the board to consider the following matters in particular. The first people let onto the land by the Andrews were Shaira Mohammed and her husband Henry, also called Stanley. He was Elvina Andrews' cousin, and he worked for the Andrews. Elvina Andrews was godmother to one of his children. We submit that in those circumstances, it is far from improbable that Elvina would say to Henry and his wife, "You can stay on the land as long as you want, and you can buy it when you are ready." And if Henry, as happened, were to bring his nieces, who know the Andrews, it would not be so improbable that the Andrews would offer them the same deal as Henry had. And on the evidence, the board would notice that they in effect told Shaira that they wanted the same kind of arrangements. I submit that the Court of Appeal was entitled to find in all the circumstances, for the reason they gave, that the respondents' actions on the land were more probably was more probable than not arose from the promises by the Andrews that they would be able to buy the land in the future. The appellant has given no reason or no good reason to overturn that finding, and I respectfully submit that the board should uphold it. Finally, the fourth point on which I wish to address your lordships in the appellant's objection, that the Court of Appeal made a finding of an agreement that was too uncertain to be the basis of proprietary estoppel. In particular, the appellant has submitted in his written case that the absence of a term as to price, the Andrews promise was unenforceable. That objection is wrong in law because proprietary estoppel does not depend on a legally binding agreement. And we have referred to two cases, Sutcliffe and Lloyd and Turner and Major. I won't go to the case, but those cases show that it's different to contract, it's different to establishing a contract, that you have to look backwards. And therefore, you do not look and see whether there's all the necessary terms that you would require for a contract.
Do you have a paragraph reference?
Paragraph 56 and 57 of Turner and Major.
Thank you.
That is tab 28, page 3644. And the other case, Sutcliffe and Lloyd, is tab 27, paragraph 38, which is at page 3625. I would spend a short time on the alternative. Estoppel had arisen by acquiescence. I submit that the Court of Appeal was right to make the finding. They correctly identified where the case was raised by the pleadings at paragraph 52 of the Court of Appeal Judgment, Volume 2, page 877 to 878. An additional reference would be at page 27, paragraph 12.5, and page 33, paragraph 17. If I can take you to the Court of Appeal judgment. What page that? I better take you both to that. In the judgment, if you look at paragraph 52, that is volume 2, page 878, 877, 878. Wrong thing. You look at paragraph 52. So, in the light of the Court of Appeal's finding, the relevance of estoppel by acquiescence is limited. It would only arise where there had not been a promise by the landowner to the tenant. The Court of Appeal found that there had been a promise.
The Court of Appeal deals with it in more detail later, don't they, when they go through the law?
Yes, ma'am. Court of Appeal dealt with it
69 onwards.
Yes, paragraph 69 onwards. And quoted at paragraph 74, the Dyson principle. And my friend has not shown anything that was wrong in that assessment. We submit that the Court of Appeal found the fact that the respondents believed that they had security of tenure indicated more probable than not that the Andrews had made them a promise as they claim. But if the Court of Appeal could not go so far as to find a promise, it remains an unassailable finding that the respondents acted in the belief that they had security of tenure by building permanent homes, and their landlord acquiesced in that. Those are sufficient ingredients on which to found an estoppel by acquiescence. The respondents' actions were known to their landlords, and for the reasons given by the Court of Appeal, those actions were not explicable except by the belief that the respondents had security of tenure. And I rely on the BB and Sterling case. Then I go, the last issue is a question of relief. If you go to the judgment of the Court of Appeal at paragraph 79, the board would see that the Court of Appeal gave an extensive consideration of the issue of detriment. And I asked the board to note paragraph 80 and going on to 81, the weighing process. It considered the disadvantages suffered by the appellants. Then two of the appellants had lived on the disputed land for over 50 years, and it considered that what they did on the land and the value of the premises. And then at paragraph 83, it considered the advantages enjoyed by the appellants. And then it says for the court to quantify any equitable interest based on, as established on evidence at paragraph 84. Then at paragraph 86, however, after construction of homes and occupation of premises for over 50 years, the appellants are now elderly persons who should not at this stage of their lives have to be dispossessed and seeking alternative accommodation.
Would Mr. Strang be able, without too much difficulty, to tell us the age of your three clients when they gave their evidence? If possible.
Yes, sir.
Forgive me, Mr. Maharaj.
No,
please continue.
Yes, ma'am. And then paragraph 88, while the appellant insisted they were not statutory tenants in the special circumstances, similar to those other persons that there was evidence of, they had built homes at paragraph 89 on rented land. Those homes had been occupied by them for decades. It would be inequitable for them to have to raise finance hurriedly to purchase the land on which their homes stand, as failure to do so within a constrained time frame could result in loss of their homes and negation of their equitable rights. The appellants have passed their working lives, and the opportunity should be afforded for such purchase to be made by heirs or potential beneficiaries. While recognizing that their legal position are not identical, the appellants with equitable rights should therefore be afforded a remedy consistent with that of the persons who were statutory tenants and who had renewed their statutory tenancies. So that is the rationale that the Court of Appeal used, my Lord. The respondent sought to claim possession after what he considered to be the expiration of the date of the alleged statutory tenancies, May 31st to 2011. This is important because the statutory tenancies expired on the 31st of May 2011. And what was happening from the evidence, this defendant was collecting the rent. So he collected the rent up to July 2011, which it was paid earlier in the year. But then he stopped collecting the rent by telling them that he will let them know because he has to do certain things. But he never informed them that he was thinking of evicting them. So after the date passed, is then he took steps. After they had tendered rent for some years and he refused, he told them that hold the rent for the time being. Then when he served the notice, although they had a check for the rent, he returned the check. So what happened, it is in that context that when the pre-action protocol letter was written, it was written on the basis that there was an alternative claim, because we were saying that by collecting the rent after the time or before the expiration and of the statutory tenancy, for a period before the expiration of the statutory tenancy, it could have meant that there were still statutory tenants. And now these were old people given instructions, and you couldn't get all the instructions at the same time. So the fact that there were some of these inconsistencies, I would ask the court, and the Court of Appeal would have considered that those issues of credibility did not have any bearing on what was before the court if it had to make findings and revisit the judgment. My Lord, Ms. Gomez, she was 67 at the date of her witness statement. David Sami was 78 at the date of his witness statement. And Shaira Mohammed was 87 at the date of his witness statement. And the trial occurred 2 months later.
Thank you.
So what I would say in respect of the question of relief, that the Court of Appeal, through Justice of Appeal Rajkumar, reminding himself of the principles for the exercise of the court's discretion, and went on to apply them to the facts of the case. It was for the appellant to show that the Court of Appeal went plainly wrong or stayed outside the wide boundaries of the discretion. I submit that he has not done so. There is no merit in the appellant's suggestion that the Court of Appeal did not identify the disadvantages suffered by the respondent. They did at paragraph 77, page 887, beginning by such investments, and also at paragraph 82 at page 890. There is also no merit in the complaint that the Court of Appeal did not identify the minimum equity. That is expressly the task that the court set itself, and see the heading at paragraph 79, page 888. In particular, the appellant is wrong to suggest that the Court of Appeal ought to have found that the equity was satisfied by the fact that the respondents had been allowed to live in their homes at a low rent. We submit it is one thing to be allowed to live at low rent in another person's house, but another thing altogether to build your own house. And in this regard, we refer to the judgment of Justice of Appeal Jamada in the Esther Mills case, which is at tab 13 of volume of the authorities, paragraph 33 at page 3297. Yes. One of the issues raised in this case, my lady and my lords, is that there was a common social phenomenon, and that led to the passing of the 1981 Act. But our submission is that the passing of the 1981 Act says nothing about the specific circumstances of each person dealt with under the Act, nor what assurances may have been given to their tenants by any given landlord. It just applies in a broad brush solution to a wide range of circumstances. It may have swept up many thousands of proprietary estoppel cases. It was an error of law to use the Act to dismiss significant work that was done in this case. So in summary, in our respectful submission, is that the Court of Appeal was entitled to revisit the findings of the learned judge. 2, the Court of Appeal was right in the findings it made in respect of the proprietary estoppel, based on the inferences it drew from the undisputed evidence in the case. And 3, the Court of Appeal was right to make the finding of estoppel by acquiescence as an alternative remedy. It was open for the judge, it was there, the judge failed to consider it, and the Court of Appeal was entitled to revisit that and to make its own findings. the question of credibility in this case, as advanced by my learned friend, does not have the relevance that it would have had if the Court of Appeal had drawn inferences from assessment of credibility made by the trial judge. In those circumstances, an appeal court is restricted and restrained from trying to substitute its own decision. This is an appeal in which the Court of Appeal considered the issues of credibility made, but made its findings on inferences drawn from the undisputed evidence in the case. So with the greatest respect to my learned friend, the board ought to dismiss this appeal, unless I could.
May I just ask one question on relief? And the established authorities show that it must be the minimum equity which is ordered. Why is it only half the market value of the land alone? Why not all the market value of the land alone?
I think what the Court of Appeal did, it used the formula in the 1981 Act. In that in the 1981 Act, when you get a lease, and you have to exercise the option to purchase, you pay half the market value as the price.
Well, basically, they were treating the equity as, because of the situation, that they should be treated as if they had given the required notice under the 81 Act.
And what they did is that they gave the 15 years tenancy.
Yes. Yeah.
Because the court obviously recognized that they would have heirs, and the heirs would be able to buy the land and etc. But in the meantime, they would be able to occupy it as tenants.
Mr. Maharaj, I'm afraid, speaking entirely for myself, I still don't quite understand why it is fair that your clients should be able to exercise an option to purchase with a valuation as at the date of the expiry of the 1981 tenancy, rather than as at the date when, in the future, if at all, they exercise their options to purchase. Why is that fair? We're talking about the minimum equity required to do justice.
My Lord, the Court of Appeal considered all the facts. They took the advantages, disadvantages, and they exercised that discretion as being the fair decision to make in the circumstances.
Correct me if I'm wrong, the 1981 Act option to purchase is an option to purchase at a value as at the date when you give notice that you want to exercise it, is it not?
Yes, my Lord.
Well, if they were borrowing from the 1981 Act because they thought that was a good way in to serve the equity, why not adopt that date for the valuation?
What they were doing is that they were using the date when the tenancy came to an end.
They were. They were.
And I should mention something as you raise that, my Lord. The mathematics that my friend used about the value of land of $10,000 for the purchase by Mr. Hanif Mohammed of the land, and therefore each lot would be worth $100. That is uncertain because we do not know in relation to the other lots where they were, if they were mountainous lots or if they were as good as these lots. But coming back to the point, my Lord, the Court of Appeal had to make a decision on the basis of what was before it. And they exercised that discretion by fixing that as the date for the value, my Lord.
Thank you.
Mr. Strang, do you wish to follow? Mr. Benjamin.
As a matter of housekeeping, we do have for Lord Carnwath, and those of you who are interested, the extract from Spry. It's over there. If I can get some assistance. I'm not going to say anything about it. I'm just going to let you know.
You're just going to let us see it?
Please.
Yes. Thank you.
Thank you very much.
Deeply obliged, and for those who have assisted. going beyond and above the call.
Thank you.
I promise not to go over my allotted 15 minutes. Can I say something about the very last point that was the cause of an exchange between Lord Wilson and my learned friend?
Can I just note, what edition is this?
It's the 8th edition. We couldn't get our hands on the 9th edition.
No, I don't.
But, my Lord, overnight, if you would give us enough.
I'm sure we can find it. It's just,
yeah,
it didn't say on the top what it was.
Yes, I apologize.
This is the 8th edition. There's a 9th.
Bit of a hurry.
Thank you.
It was open to the Court of Appeal to ask for assistance on how it should quantify the minimum equity. It didn't do that. The choice that it took, as a matter of policy, was to ask counsel, both Mr. Mirage and Mrs. Peake, whether they would leave it to the court. And so that's what they did. And we say with respect, there is no rational, and I mean legally rational or jurisprudentially rational basis, if you are going to decide within the remit of your equitable discretion that this is what meets the minimum equity for the, with respect, arbitrary choice of date. We know where it comes from, but there is no connection to the equitable remedy at all, respectfully. It's an analogy, and we all know in law that analogy is taken too far up to mislead. And just because I was hearing the exchange, I just thought I would make those observations. There was another exchange between my learned friend and the board about what was the appropriate social phenomena. My friend advanced a position which I think ended up like this, where he says, and again from his experience, that the social phenomena in terms of tenants going onto land and building was that they would build a removable structure first, and that over time a more permanent or irremovable structure would come into being. So there are 2 points to be made about it. One is factual, one is legal. As far as the factual point is concerned, when you come to look at the detail of the evidence as to what was built by each of these respondents, you will see that they each started off with a very modest but concrete permanent structure. In one case it was 12 by 12, in another case it was 20 by 20. So they built small, I'll use my friend's phrase, structures that could be destroyed if necessary, but they built modestly is the only qualification that I want to make on the evidence. I don't want to try to give any evidence from the bar table. So that the evidence on the record shows small, modest structures being built and then expanding over time. An additional garage, additional kitchen, and so on. The details of which don't matter for the purpose of the observation that I made, my Lord.
Without inviting you to give evidence.
And I'm not going to.
I'm not inviting you to give evidence. Would those have been regarded as chattel houses?
My Lord, in 1958, any permanent structure would not be regarded as a chattel house.
Right.
Parliament, because Parliament can so do it, in 1981, altered the definition of what a chattel house meant, so that it included the removable, the concrete structure that one, if imaginatively, goes in the back of the trailer, together with any structure that was permanently affixed to the ground, concrete, steel, plumbing, electricity, and the like. So that's the best that I could do legally.
Well, this is Section 2, isn't it, of the 1981 Act, that defines chattel house to include a structure which is affixed to the land in such a way as to be incapable of being removed from its site without destruction. So it obviously changed the definition from what had previously been.
And really, although my friend takes a little bit of an issue with what is said by Lord Walker at paragraph 5 in Gopal, in fact, the statutory language is consistent with it. In other words, that they were faced with a particular...
And you were saying the judge was wrong to describe this as a chattel house at paragraph 71.
No, my Lord, I'm not saying that she's wrong, because I'm saying that every single legal practitioner now thinks of a chattel house through the lens of the statutory, definition. In other words, it has infected the way that we think.
Isn't that what I'm trying to understand the relationship of the facts of this case
Yes.
to the way Lord Walker described the problems of people building what's
Yes.
generally chattel houses, and then they develop over time into very substantial structures.
Well-
and we get the 1981 Act, which treats them all as chattel structures.
Yes.
But the judge was, I assume, aware of that background, and she talked about this as being, in paragraph 71, the land was rented to the tenant specifically for the purpose of the erection of a chattel house used as a dwelling. Now, are you saying that was wrong?
No, my Lord, I'm not saying that it's wrong. I'm saying that the facts of this case exemplify the social phenomena identified by Lord Walker in paragraph 5 of Gopal. That's what I'm saying. I'm saying that on the facts of this case, factually, a very modest structure was put up. It was capable of destruction, but not necessarily movability.
What I'm not saying, you see, Lord Justice Millett talked about, someone puts up a house in this country,
Yes.
one draws certain inferences.
Yes.
But in Trinidad, the period we're talking about, people were putting up structures which start modestly and then expand
Yes.
without any title at all.
Absolutely.
So why is this case different? The judge seemed to be saying, well, this case is no different to that, and therefore one can't draw the inference that there was any particular option to purchase. Isn't that what you're saying?
Yes, that's exactly what I'm saying. That's exactly what I'm saying. I'm saying that the facts of this case, and I haven't taken you to it, but all of the judges at first instance, and Justice Jones was not been alone, would have decided many cases that give rise to this kind of issue. Some of them get reported and some of them don't.
The problem we have is that the Court of Appeal presumably are aware of this as well, and yet they decided the judge had misinterpreted it.
Yes, and so the question that arises is whether, in fact, that's a sound conclusion, and of course my lords have my submission on that. There's no value in repeating it, I think.
Thank you.
I note that in Esther Henry, the
Yes.
Court of Appeal said, quoting
Mills,
the Chancellor
Yes.
in Dilwyn and Llewellyn, no one builds a house for his own life only, adding, this is the Court of Appeal, that insight is no less true in Trinidad and Tobago. That's what they said.
It's all very well, but we've got Lord Walker describing what was going on. I think neither of them are necessarily the right people to decide. Anyway, there we go.
Well, we have to read all of these judgments in the light of what the dispute was that was being resolved.
But the Court of Appeal did emphasise the substantial nature of the buildings.
Yes, they did, and I am not going to say to you, because there was a question my friend was addressing, I think a question from Lord Wilson, as to whether the judge adverted to the extent of the work, and she didn't. And the reason why she didn't is because it was not an issue in the case. In other words, I take you to paragraph 20 of the defense, there was no issue of fact between the parties as to A, where they were in occupation, and B, what was the nature of the dwelling houses that they had built. That was not what she was called upon to decide. And I say with respect, it's slightly unfair when one sits at first instance for the Court of Appeal with the benefit of a sort of 2020 vision of hindsight mirror, saying, well, I want to look at the possible inferences that can be drawn from a fact in respect of which I'll go even further. There wasn't a shred of cross-examination on it. It was not an issue.
Facts are sometimes relevant too.
Absolutely, my lord. But all that I'm saying, insofar as the judge, like any first instance judge requires defending, is that you are constrained by the case as it is presented to you. And every advocate knows any one case can be presented in an infinite, perhaps I'm exaggerating, but you get my gist, of a number of ways. And that's what's happened in this case. And I respectfully ask the court to determine whether, in this instance, this is an appropriate case for you to decide that the relevant appellate threshold was met, because that's really what has happened. I was going to take you to one of the cases in relation to the social background. Can I just ask you to look at it? I'm not going to, it's tab 25, volume 2. And it is helpful because it tells you of another social phenomena, and now I managed to lose my bundle of authorities. Oh, right. It tells you of another. So it's a case decided at first instance, and it is simply, if I could invite you to page 3546, I trust my lady has it. It's the case of Simon against Polyne. It's a decision of Mr. Justice Ronnie Bodo Singh. It involves notice under the Land Tenant of Securities of Tenure Act. If you skip forward very quickly to paragraph 34, you will see Gopal and Bash, which is the earlier of the two decisions, I think. Paragraph 5 and 6, which you've already had shared with you, are referred to. They're quoted in paragraph 5. You will see at paragraph 38, his lordship talks about, or confirms, or affirms the social context. And in this case, I believe, and I'm not able to pick it up because I did it from memory, that the fact that the 30-year period was coming to an end was something that was publicized, and I think his lordship, I'll just ask Mr. Kawalsingh to find the relevant paragraph, and you saw that in the material that was before you, that even though the fact that the Land Tenant Security of Tenure Act was coming to an end, and it was publicized, in other words, there were notices published in the newspaper at the behest of the state, the parties purported not to have any knowledge about it. And I'll get that for you in a moment. My further point, as a distinct point, can I simply ask you to look carefully at paragraph 65, rather, of the learned judge's judgment. And so just before I do that, the paragraph I was wanting to refer you to was paragraph 55 in the decision of Simon and Polyne. Yes. And I'll just read it to you so that you get the gist of it. This claim must be seen in the context that Parliament had extended the period for the renewal of statutory leases by Act number 10 of 2010. If you look at the cover sheet for the Land Tenant Security of Tenure Act, you will see that confirmed, that it was amended. And there had also been, and this is important, a substantial public information campaign to inform tenants of their rights, as noted earlier and so on. In other words, there was a serious public relations attempt to make sure that those who might not otherwise be in the know had their rights, or the fact of their rights, brought to their attention. And I think it goes without saying that these would be people who perhaps might be expected not to be as familiar with legal issues as otherwise might be the case. I was asking respectfully a moment ago for you to just invite your attention to paragraph 65, just for one very small point. And simply to say that although my learned friend made the submission that the learned judge did not apply her judicial mind to the alternative case, in the very first the single sentence of paragraph 65, that's the case that's being put by Mr. Maraj in relation to his client's position. He's saying there specifically to her that the fact of the permanence of the buildings erected on the land and the money spent by them is corroborative of the agreements. But also, he is saying there, and he said it a number of times in the course of his submissions, that the single facts, or the two sets of facts from which the inference could be drawn was A, the family relationship, and I don't propose to spend any time on that, and B, what was on the ground, I think is the phrase that he used a moment ago. In other words, the permanence of the buildings. So that the judge did have her attention drawn specifically, respectfully we say, to what was the alternative case, and she rejected it in the context of the others, of the principal case. This is the very, very tiny point, but can I say that I'm a little bit surprised that my friends did say that in the Court of Appeal, Mrs. Peake made a concession. I didn't think we were going to get into that at all. I think what she did say, in fact, that she wasn't in a position to respond to the Court of Appeal in relation to the exclusion order. And that's why she was given further time, and that's why the letter of the 14th of October 2016 came about. I have listened with fascination to the board's exchange with my learned friend in relation to the provisions of the Rent Restriction Act. And I apologize for not drawing section 14(1)(f) to your attention. I couldn't possibly improve on the exchanges that took place between the board and my learned friend. I say that if you are sitting on the fence, come down on my side as far as the correct interpretation of the exclusion order is concerned, because that, I don't think you are, but if you are...
don't draw any conclusions at all.
I never do.
To council.
Can you just help me? I'm
Yes.
trying to understand the sort of thinking behind all this, because it seems as the Rent Restriction Act
Yes.
applied to building land before the building is completed, because the exclusion order only applies to completed buildings.
Yes, but my lord, I'm not sure that the correct articulation of those two things
No,
is a little bit difficult.
assume you're wrong on the interpretation.
Yes.
According to you're right,
Yes.
that the exclusion applies to buildings including the land on which they're built.
Yes, yes.
But until they're completed, as far as I can see,
Yes.
the Act continues to apply.
My lord, I'll be frank with you, that is a possible interpretation that did not enter my contemplation.
Yeah.
But that's why I'm here, in a sense.
So today, because I haven't completed the building, I'm still protected. Tomorrow, I'm going to complete the building,
I'm not protected.
and then I'm not protected.
And what
That's
happened
not
when
much
I
use to man
completed
or
by
beast.
stages? It's very odd. Anyway,
That exchange just really lends support to my interpretation, really, my lord.
all right. Well,
I'm not being mischievous. I'm just trying to make sure that I don't spend any more of your time unnecessarily. My lord, again, paragraphs of the judgment. Paragraph 71 of the judgment of the learned judge. And the second sentence is important, because this is a recognition by the learned judge that, which is not clear from the judgment of the Court of Appeal. Second sentence, this was land rented to the tenant specifically for the purpose of erection of a chattel house used as a dwelling. So without reverting to our earlier conversation about what was meant by chattel house, all I'm simply identifying here is that this is a specific fact, i.e., the purpose to which the land was put at inception, which it's not clear that the Court of Appeal had that particular fact in its contemplation when it came to its conclusion about the permanence of the buildings built afterwards. Because, of course, what the Court of Appeal was concerned to try to decide was, well, what was the state of affairs, and I use that term neutrally, at the moment of going into possession. So whether it is A, an option to purchase, or B, a state of belief, it's really at that moment that the question needed to be determined, and not subsequently. Of course, it is perfectly in order to look at subsequent events for the purpose of determining what they might tell you about that moment in time. But really, that was the critical question. And then that leads me to my allied submission, which is that insofar as the learned judge, and my friend hasn't contradicted this, felt able to say, I can't accept what the respondents have said, we say with respect that that's a finding of primary fact, i.e. what was the state of their belief, that was put at issue by the pleaded case, and that goes in the same direction as all of the other findings as to credibility. In other words, your utterances about what you had in your contemplation at a particular point in time retrospectively is quintessentially a question for the primary fact finder. And we say, insofar as you try to get around that question by relying upon an inference from the permanence of things that they did weeks and months afterwards, we say with respect that's a weak logical connection between the two, as opposed to a strong one, either for the primary finder of fact, I accept the evidence that you've given, or I do not. Lastly, can I just double check this reference before I spend time on it? Can I just invite your attention to page 1684? It's the witness statement of Shafina Ali. I mentioned it in opening, and at paragraph 3, she says, and because she's a contemporary of Shaira Mohammed, after I got married, my father built a house for me and my husband on the lands. Shaira Mohammed was already living there in a wooden and concrete house, so her description is a little bit different from the description being given by the other witnesses, but I accept wooden and concrete. When I moved in 1964, so you can see that she is 6 years after Shaira Mohammed, but before the other two, which is to say before Mary Gomez and David Sammy. So, my Lord Wilson, it's volume 4, 16. I've got.
I'm sorry.
No, my Lord. I'm
getting there slowly.
Not at all, my Lord. I'm not trying to press you.
Yes.
Yes. So I was reading, my Lord, from 1684. It's paragraph 3 of the witness statement of Shafina Ali,
Yep.
in which he said, I got married. My father built a house for me and my husband on the lands. Shaira was already living there in a wooden and concrete house when I moved in 1964. So I just paused there. Another instance where what the appellant was doing was not contradicting, not putting in issue, in fact, giving corroborative evidence about the extent of the building works that had been done at that stage, and therefore, I asked the board to be reticent in any criticism of the judge, because this was not something that she mentioned in her judgment. And I say again, it was not an issue, and I go on to say that she describes the direction of the house. When I moved onto the lands, I started paying rent to the Andrews. They never made any promise whatsoever to me or my husband in relation to the purchase of the lands that I occupied. This was never discussed at all. So she gives an entirely different account from that of the respondents.
Is she your client's sister?
She is my client's sister,
Very well.
and it was put to her, my Lord Wilson, that she had come there to give evidence in support of her brother, and she dealt with that.
Very well.
So all I say is that this was material that the Court of Appeal does not refer to and does not mention in its judgment, and in the interest of completeness, it ought to so have done. My lady, unless you have a question for me, that is all that I need to say by reply.
I'm just checking.
Yes, I can see that.
It would appear that nobody has any more questions to put to you, Mr. Benjamin. I think we would all like to say thank you to everybody who's been involved in the presentation of this case before us today, not only those who've been on their feet, but those who've no doubt done a lot of hard work behind the scenes. Thank you for the helpful spirit in which this appeal has been presented. We've all had a thoroughly enjoyable day. Now, of course, we're going to go in for the less enjoyable task of working out what our judgment will be.
Lady, can I be so bold as to speak on behalf of my learned friends and I and say the following 3 words? It has always been an exquisite pleasure to be before you and the rest of the board.
Thank you indeed, Mr. Benjamin. Thank you.